We have a web page on the Broadcasting Treaty, and I'll be referring to documents from this page. The first document I'd like to bring up is it's this paper that Sean also has on his web page called "The Trouble with the Broadcast Treaty." If you look at the table of contents, what you'll see is it's really a historical document on the evolution of the negotiations, and it really focuses and Bert, who will speak later, has done a nice job of a line-by-line analysis, focusing on the most recent text that will be discussed. I don't really focus entirely on that. In fact, a lot of what's in here are statements that were made 20 years ago or 10 years ago, or during the course of the negotiation. I tried to capture in here the debate, the arc of the debate on the treaty. I focus more on some issues than other issues. Sean has really done an outstanding job of addressing the challenges and the limitations and exceptions provision, which would make this worse than it would give basically a worse framework for exceptions that exist for either the Rome Convention or any of the copyright treaties, because it it starts with the idea that you can have the same exceptions you have for copyright, and then it imposes a restrictive version of three-step test on top of that. I think one thing that you will notice in this paper is that in the previous treaties on broadcasting or satellite transmission, including the provisions in the Rome Convention, the Brussels Convention, as well as the TRIPS agreement, there's no three-step test in the exceptions that relate to broadcasting organizations. That includes the TRIPS agreement itself. Now, the TRIPS agreement does have a three-step test, and there's a very technical explanation, which we're submitting because we were asked to by USTR in a separate proceeding on the special 301 list, which I hope to be able to share later today. But whatever you think of the three-step test is as it relates to copyright, it doesn't appear at all in the Rome Convention. It does not appear at all in the Brussels Convention, and in the TRIPS agreement, they have the three-step test applying to copyright in a way that's nuanced, but in the exceptions that are mentioned for broadcasting and other related rates, it's not there. So I concur with what Sean said. There's a lot of problems in the exceptions part of the treaty. I think what I'd like to focus on is in terms of the current draft. The big issue, the elephant in the room in this treaty, has always been, I think, or elephants, I should say, are really two issues. One, to what extent does the treaty give rights to broadcasters when they don't own, when they don't create, own, or license content? Because, for example, if you look at right now webcasting and streaming, if you look at what Netflix does, if you look at what Amazon Prime does, if you look at what Disney Plus or Paramount Plus or a million web pages, including this event itself would be covered by, as far as I understand it, for the definition, this would be covered by the broadcaster. You would have a broadcaster right to this performance, but really almost anything. If you're, I mean, Twitter would qualify, Facebook would qualify, YouTube certainly qualifies. So under the definitions that they have, it's right now, in order to acquire rights to content that you didn't create, you either have to acquire the rights from somebody, or operate under some kind of a compulsory license, typically one that involves remuneration to the creative communities. Now here the rights are just automatic. If you take something in the public domain, something under a Creative Commons license, if you take a congressional hearing where the cameras are operated by the government, if you take a work that where it's clearly where the people are trying to promote the distribution of it, like for example, a lot of groups that work on campaigning right now, they create videos and they try and get them to go viral. I mean, they want people to take those videos and post them on Instagram or Facebook or Twitter or different kinds of the Fediverse or something like that. They want these things to be used and republished, and you know, and if they make it onto a news program, they're like, that's like a home run. So there's all kinds of content that people do where the creators of the content actually are encouraging people to use and reuse the information. And there's also people that are creating things that would like to be paid or compensated or have some control over the thing if the content's used by the broadcaster. The broadcaster, the one right that there's one right that we're very concerned about, and I think everyone's going to be focusing on, is there's a right of fixation in Article 7. It just says broadcasting organizations shall enjoy the exclusive right of authorizing the fixation of the program carrying signals. What that means is if they broadcast a program, whether it's a public domain program, it's some public, some user-generated content that's uploaded, if something that took something that was streamed by somebody from their cell phone, and they, you know, and they didn't really have a contract with them or anything like that, they just put it out there. If they pirated something, it doesn't make any difference, even if it was infringing. The broadcaster would have an exclusive right to authorize the fixation of that programming thing. Now, there's no term in this version of the broadcast treaty, and there is no term in the Brussels Convention. Now, one thing in that very long paper I have, and I think I've shared some of these notes in some shorter emails with people. This was a discussion in the Brussels Convention because it also has no term. It's also, you know, the model for like a signal-based treaty, the broadcast, the 1974 Brussels Convention. Now, the delegates were asking themselves in that discussion if the lack of a term meant that it was perpetual, or if it just disappeared immediately. I mean, they were trying to figure out what the consequence of not having a term in terms of the type of protection that were there. And it was described as a tough nut to crack in the negotiations during the Brussels Convention, and it's a tough nut to crack here. And the answer is just completely unclear. Are these perpetual rights, or are these like rights that disappear once you have the fixation? Because to have a right to fixation, what does it mean if you're fixing a signal? And in the definition, it appears to be perpetual because they talk about the act of fixation involving a signal. So I think that what you're potentially looking at here is the broadcasters acquiring a perpetual right of fixation on content they don't create, they don't own, and they don't license. Now, if this was just related to like the Rome Convention was to like a terrestrial, on the air, free television and radio, I don't think people would care that much. But as you move to digital technologies where the ability to copy things at high quality is really enhanced, and then you add the massive explosion of the uses of streaming by everyone, including pretty much everyone with a cell phone, it really makes a big difference as to what kind of liability you're picking up as information is sort of broadcast, copied, rebroadcast. The whole term of things going viral is pretty accurate. If you look at a lot of the news reporting, you see all kinds of footage taken by some spectator, for example, in an event that's just goes, you know, it sort of moves from one platform to the other, and without it really getting any contracts or anything. Now, if you're ever trying to clear rights, it becomes quite difficult and challenging to figure out who has a right of fixation on this thing, because you can have the same work being copied and recopied like 100 times, and would that mean you'd have to clear rights from like 100 people, for example? And if you didn't clear the rights, I mean, what are your liabilities? So the right of fixation is this huge unexplained thing in the broadcast treaty. And it's also really not clear why they need a right of fixation. I mean, the broadcasters that are doing streaming on the internet, as all of us that are paying money for all the streaming services we're currently consuming right now, and like whatever you were consuming in streaming services 3 years ago, you probably are paying for twice as many services today as you were like 2 years ago. We all know that they have those are encrypted, and you have passwords, and it's already against the law to hack those things. And they're not free for the most part. I mean, some are free, but lots of them, some are advertiser supported, but a lot of them are definitely, you have to pay for it. And even this cast right now is you have to register to use it. There's some control over it, but the idea that somehow you give everyone that streams something some kind of an intellectual property right, a right of fixation, in addition to the other rights, is a highly problematic point of view. Now, what I think Bernd is focused on in his paper, and he can explain it himself, but there is this Article 10 in the current draft of the treaty that it says other adequate and effective protections. So people look at Article 10 and they say, well, the broadcast treaty is not too bad because, frankly, you don't have to do any of the stuff that's in the broadcast treaty. And, you know, you can make, effectively, you can make reservations. You can say that we're not going to include webcasting, even though it's included right now in the main definition. You can narrow it. The U.S. doesn't have to change its law. They can just do things as they've always done. So there's all these provisions and options in this menu in Article 10, which are designed to make it difficult for a country to justify blocking the negotiations on the broadcast treaty on the grounds that they don't really have to. They're being lobbied by these politically powerful broadcasters. You got O Globo in Brazil. You have you know, in the past you had a lot of activity by Paramount and Fox and other people on the street, and Z Network in India. I mean, you have, every country has this tradition of like very powerful radio and television because they put politicians on the air. So nobody really wants to block this thing, even if they think it's really a stupid treaty. So this Article 10 makes it look like, well, it's not that bad because look at, you can have a really weak version of it, or, you know, change nothing in your law under Article 10. The problem with that, I think, is Article 5 on national treatment. And if you look at a second paragraph in Article 5 on national treatment, it's a sort of an upward ratchet mechanism. What it means is that if you're a U.S. broadcaster operating in Germany, that you don't get the same rights as the German broadcasters unless the U.S. has the same laws as Germany has. So what'll happen is a country that has a weak implementation, like in the U.S., for example, will go to the U.S. Congress and say, you know, we're not benefiting from this enhanced protection that the people get in Europe. So we want to get a change in the U.S. law. And this is how we got to 7 years copyright term in the United States, because the rule was you had to give 50, but you could go to 70 on life plus 70 on copyright term. But the extra period would only benefit your nationals if the U.S. raised it. So when Europe went to 70 years, then the U.S. said, oh, we have to go to 70 years too, because, you know, we want our copyright owners to get, you know, the extra 20 in Europe. And that, I'm afraid, is one of the risks of the broadcast treaty, is that it'll say like, well, it's pretty flexible because of Article 10. And then you get into it, and then there'll be like this wave of lobbying, rent-seeking lobbying, where they try and get people to get the worst regime possible to make sure that we get the reciprocal rights in that country. If you look at the definitions, now, Burnt in his paper, I think, correctly said that a lot of the important features, not all of them, but a lot of the important features of this treaty are in the definitions clause. And if you look at definition E and definition H, definition A is the definition of broadcasting organization. At one point, these had to be traditional broadcasters, people with broadcasting license. So you had to become a broadcaster. I mean, American University could qualify because they have a radio station. And YouTube would qualify because, Alphabet owns broadcasting licenses. Pandora bought a broadcasting license to qualify under US law. So, but it was kind of a big speed bump. If you had to have a broadcast license, to qualify as a broadcasting organization. It meant, at least there was some small, I mean, it was a small bump, but it was a pretty significant change in who would qualify. Now, this is a little bit like eliminating the idea of if before the U.S. joined the Berne Convention in 1989, you had to have formalities to get copyright protection. And that was a great clause because it meant that it was much easier to clear rights. And it also meant that if people didn't claim the formalities, it was in the public domain. So the public domain was really enhanced by that. When you eliminated that, every time you write an email to your mother, you're protected by copyright, or post something on a social media site. So it's created a lot of problems. Now, what you see is a similar thing here in the definition of broadcasting organization. It's just a legal entity that takes the initiative and editorial responsibility for broadcasting, including assembling. The big thing are, do you assemble and schedule the programs? And that's it. And then stored programs means that they were originally transmitted by broadcasting organizations, but now it's just download on demand. So it's no longer broadcasting. It used to be one to many. Under H, it's also one-to-one. So the way they define broadcasting organizations and the way they've included stored programs and defined it, it really means this is essentially covering massive swaths of what takes place on the internet, an unbelievable massive increase in protected works. It means Twitch will be covered. It means all sorts of different things will be covered. And it'll be great for the adult the adult business. The pornography business will be one of the big beneficiaries in this because they make a lot of money off, and they're quite innovative on video things. So they'll be one of these sort of unintended beneficiaries of this treaty. If you go back and look at who's involved in streaming today, it's just unbelievably different than anything related to the Rome Convention. I mean, it's just mind-bogglingly different. And it's evolving very fast. It doesn't need the treaty. They're not, the people that are the biggest beneficiaries are not even in the room while this treaty is being discussed. And it's going to create liabilities, because even if you feel like I operate in the US, so we have like a pretty good law in the US, I'm hoping, right? Maybe, who knows? I mean, the Congress is kind of erratic these days, so kind of hard to tell. I mean, if you have some of the crazies taking place, running the asylum in the United States, which could happen, who knows what we might see, particularly, just how erratic some of the things you hear out of the US Congress are. But suppose we have a good law, but suppose we don't like a law in Europe, for example. Well, we have to worry about that, because guess what? We use the internet and we don't have geo-blocking when we stream things. And or when we use clips that we get from other places. And so then we might pick up a liability in a foreign country. And the bigger, the more your organization or business deals with more than one country, it becomes a really, really complicated thing. Now, one thing I will say is, if you're a big company like Google or Alphabet, which owns Google, or Facebook, you can hire a big team of lawyers and public policy to figure all this stuff out. But if you're a small business and you have different rules in every country, good luck trying to figure out how to comply with this thing when you see like 50 different implementations of this right across different countries, and you're not geo-blocking your content. So this has a potential to have a huge negative effect on what the internet is. And because these rights are sort of automatic without formalities. By the way, the Rome Convention permitted formalities. Well, eliminate the right of fixation. If you eliminate the right of fixation, pretty much most of the things I've talked about pretty much disappear. So the right of fixation is like pretty much the main thing. If you don't have the right of fixation, then even the things on limitation exception don't really become such a big deal. I mean, the right of fixation is a huge problem in this agreement. Secondly, we say, well, okay, if you can't do that, why don't you just narrow it to sports? People for a while were claiming that sports weren't protected by copyright, and this was live events, or some live events or something like that. Maybe you can do it, concerts or sports if you know, even though nobody really made the case it was illegal, that it was legal to hack these things, suppose that it's just sort of a graceful way to get a treaty that deals with broadcasting, but just, you know, limited to sports live events. Third thing we mentioned is a blame game. Just sort of, you know, blame the usual suspects and say, well, we would have done it, we wanted to do it, but, you know, the other guys were just unreasonable. That's a classic technique in WIPO Geneva. The fourth thing I have is just sort of like, you know, own it. Just say, look, the system's not broken. Streaming is like going through the roof. It's like, it's becoming a massive profitable thing. It's innovation's happening like crazy. Don't do something that's going to screw it up, and just actually say what needs to be said. And then the last thing I say is, well, just say, oh, well, look, before we lock everyone into a treaty that we, you know, that's like impossible to change, let's see a model law as to how you're supposed to implement this new regime. And to the extent there are problems with piracy, the model law could be helpful. Countries that don't think there's a problem, that think their national law is adequate, can just basically ignore the model law. But the model law also shows you kind of what you're talking about, because all these vague provisions in here would be kind of fleshed out in the model law. And that concludes my presentation. Thank you very much for inviting me, Sean.